Hi, my name's Nadine Udorovic. I'm one of the partners here at Nichols Family Lawyers. So today we're going to bust 4 myths when it comes to property settlements in the family court. So the first one is, once you get married, you're entitled to 50% of everything you own together. It's a very common misconception that we hear all the time. So a common myth is that once you get married, you're automatically awarded half of everything that you and your spouse own if you separate. But that's not how it works. The court doesn't just divide assets 50-50, they use a 5-step approach to determine what is fair. Step 1, should there be a division of property? Step 2, identify and value everything both people own. Step 3, look at what each person contributed, and that's both financially and in other ways such as caring for kids or managing the household and non-financial contributions. Step 4, consider the future needs of both parties. And step 5, decide what a fair division would be based on all of those factors. The court looks at all assets and liabilities, no matter whose name they're in. So if you both have things in your individual names, they're still part of the total pool to divide. A good example of this is a piece of real estate or a business or a company, which is a common occurrence where it might just be in one party's name. The court take both financial and non-financial contributions into account and homemaker and parenting contributions if relevant, and then adjust how things are split based on those specific needs of both people moving forward. So myth 2, they cheated on me so they will get less of the property. In Australia, we have a no-fault jurisdiction when it comes to applying for a divorce. The only reason for a divorce to be granted is the irretrievable breakdown of the relationship, which is shown by living apart for at least 12 months. So if you're going through a divorce, the court won't consider infidelity when making decisions. However, property and parenting cases are separate from the divorce, but given the no-fault jurisdiction, this means that if someone had an affair, it is not necessarily going to impact on parenting arrangements or a property settlement. If though, for example, one spouse has significantly reduced the marital property or wasted marital funds, for example, by wasting money on gambling or excessive spending on alcohol, the court might reduce their share because they negatively impacted the assets. So myth 3, males come off second best in all property settlements. There's a myth that men always lose out in property settlements. In the past, men were often the main income earners and women were seen as the homemakers and carers of the children. This has led to the misconception that men always lose out in family law matters. The reality is the court looks at the relationship as a whole, how long it lasted, both financial and non-financial contributions, and future needs of both parties, income of both parties, and the care of children moving forward. For example, if a wife has stayed home to look after the kids, her contributions to homemaking and parenting are just as important as financial contributions, and often they are offset against the other, meaning contributions are assessed as equal. The court can also adjust the settlement if the wife or mother had to reduce her career or put it on hold for a period of time for the sake of the family and to look after the children, to make sure she's not left with less due to her decreased income earning potential. The court's goal is to make sure the outcome is fair and just for everyone involved. Myth 4, we can't get a property settlement because we weren't married. If you're in a de facto relationship, you still have the same rights as married couples when it comes to property settlements. Since 2009, Australia's Family Law Act has ensured that de facto couples are treated the same as married couples in family law matters. A de facto relationship is one where 2 people live together in a genuine domestic partnership, even though they're not legally married. However, before you can apply for a property settlement, you need to prove that your relationship was genuine and broken down. You also have to meet one of these 4 criteria. The relationship lasted at least 2 years, you have a child together, you registered the relationship, one person made significant contributions, often financial, and not allowing a settlement would cause unfairness. It's important to know if you're in a de facto relationship, you must apply for a property settlement within 2 years from the date of separation. If you miss this deadline, you'll need special permission from the court to apply. Thank you for joining us today. If you need any further family law advice or if you'd like to make a time to speak to any of our lawyers, please visit our website in the link below.